There we are. Okay. Good morning, everyone. It is Wednesday, March the 20th. This is courtroom number one. Our docket today is landlord tenant cases. These are all second hearings, which means that everyone has had the opportunity to view the advice of rights video and received a copy with their advice or rights with the service of their summons and complaint. That being the case, and I see the attorneys are here. Let's start getting people matched up. Two four zero one one eight seven LT. This is Willow Glen versus Pope. Your appearances, please. Your names for the record.
Good morning, Your Honor. John McCausland, representing Willow Glen.
State your name for me, please, ma'am.
Creasia Pope.
Today is the day and time scheduled for the second hearing in this matter. Ms. Pope, the court received information that your application for rental assistance had been denied. Is that correct, ma'am?
Yes.
Mr. McCausland, what is the rent to retain possession in this matter?
Your Honor, first I'd like to inform the court that Ms. Pope and I have agreed to the terms of a consent judgment, which we'd ask the court to adopt. The rent to retain possession is $548.28. The court costs are $191.93 for a total balance owing of $740.21. Ms. Pope will pay that or move by April 2nd. I've informed her that she has a 3-day period in which to advise the court and file a motion if she thinks that we have misled her in any way, in addition to a period in which she can appeal this judgment that expires on April 2nd. I have her consent to sign her name to the judgment.
Thank you, Mr. McCausland. Ms. Pope, you were able to hear the attorney just now?
Yes.
And is everything he said true and accurate?
Yes.
You wish to agree to entry of a judgment with the total amount due of $740.21, and you will pay that amount or vacate the property by April the 2nd.
Yes.
And ma'am, you were present previously when the video played that explained the rights available to you.
Yes.
Do you have any questions about the rights available to you in this landlord tenant matter?
No.
Do you have any questions about the consent judgment that will enter?
No.
And Mr. McCausland's office will prepare it, present it to the court by electronic filing. I will sign it. And a copy will be mailed to you at the address we have on record. Anything else this morning, Mr. McCausland?
Yeah, I would just like to clarify that even though Ms. Pope has the right to tender the $740.21 on April 2nd, this judgment does not include the April rent. Just want that understood. I'm sure it was, but just in case.
Ms. Pope, were you clear on that?
Yes.
Okay. Anything else, Mr. McCausland?
Nothing. I will submit this immediately. Thank you.
Thank you. Anything else, Ms. Pope?
No.
Ma'am, you're free to go. You have a great day, okay?
You too. Thank you.
Thank you. Mr. George.
Good morning, Your Honor.
Good morning, sir. Are you here for someone specific or are you just waiting to see if someone wants your assistance?
For now, I'm just waiting to see if there's anyone who wants our assistance. Patricia Pruknick is also here and has co-host powers. I do have a hearing coming up later on, though, at 10 a.m. that I'll be appearing on.
Thank you.
Thank you.
This is 2401100 LT. This is Rawsonville Woods versus Mood and Mood. May I have your names for the record, please?
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Rawsonville.
I'm Aaron Mood. And I'm Dervin Mood, right here.
Thank you. Today is the day and time scheduled for the second hearing in this matter. Mr. Morton and Mr. Moods, would you like the opportunity to speak to one another?
Absolutely, Your Honor.
Yes.
Let's get them moved into a breakout room.
Hello, that's me. Yeah. Hello.
Yes, sir. They're moving you into a breakout room. And Ms. Wilson, I saw your comment. We'll get you moved into a breakout room with the representative from Lakeshore Legal Aid.
I was gonna say, Your Honor, just for the record, I don't have co-host capability right now. I know it's so that I cannot
We'll
assist.
get Carly to set you as a co-host here and get
Thank
you
you.
moved into a room. You're welcome. Ms. Holt, we received communication that Mr. Devlin is in another courthouse. As soon as he is free and back in this session, we'll get you connected with him, okay?
Okay, thank you.
Thank you. Have we seen anyone from Levine's office yet this morning?
No, I don't see anybody from Levine's office.
Thank you. Ms. McLemore, I haven't seen anyone, and their first case is not scheduled until, I believe, 9:30. But as soon as
Okay.
we see them, you want us to get you connected with
Absolutely,
them?
yes. Yes, please.
Okay.
Thank you.
I'll keep an eye out.
Thank you.
You're welcome. Good morning.
Morning.
Good, what's going on?
Nothing, I looked for you in your office, but it was dark.
9:00.
This, I guess there's people here for 9:30.
People physically here?
Yeah,
Okay.
Holiday Woods, is that their Holiday Woods case?
Yeah.
The parties are here. There's subpoenas. saying-
Holiday Woods.
What do we have at 9:30?
9:30, Swan Creek. Oh, West Village, maybe?
Yep, that's it.
Who are the people who are here?
I think it's the manager and the resident.
Not the manager, I just saw Miss Samples.
Is she nutty? No.
No, Miss Samples is here, because I've talked to her. There must be someone else here.
All right, let me go figure it out.
Thanks.
Judge,
They-
Miss Ward is here. Irma Dixon, I mean,
Yeah.
not Irma Dixon, but Askew.
I know. I knew she was coming in person, but he's talking about people being subpoenaed.
Oh, that I don't know.
Exactly. Yeah, I
I'm
think I know
sorry.
what's going on. That's
Yeah.
okay, you're fine. But I'm gonna call the rest of the 9 o'clock, the failures to appear, so that we can get Ms. Banky and Mr. Wasbury on with what else they need to do for the day. This is 240-11710 OT, Premium Homes versus Corey Nemeth. May I have your appearance, please?
Good morning. May it please the Honorable Court. My name is Jill Banky. I appear on behalf of the plaintiff, Premium Homes. Present on the Zoom is my client representative, Kosai Shamoon, and I just heard Mr. Nemeth pipe in.
He's on by phone and they just relabeled him. Sir, would you state your name for me, please?
My name is James Nemeth.
Did you say James?
Yes. Yeah.
Where's Corey Nemeth, sir?
Corey's out right now because of his he's trying to get his insulin for his blood pressure and his sugar.
Today is a day and time scheduled for the second hearing in this matter. The last time that we were here, Mr. Nemeth indicated that he had retained an attorney. To the Mr. Nemeth that's on the phone, sir, are you a licensed attorney in the state of Michigan?
I'm not.
Okay,
I'm not a
sir, the
licensed
court
attorney,
has
but
not
I work
received
with-
any information.
Oh, I'm sorry.
No, you go ahead.
No, I did reach out with Kelly, the investor, and I did also reach out to my attorney.
Sir, I can't hear you. You reached out to whom?
We had a conversation yesterday, the attorney with my attorney, and my attorney was under the where there was Corey's attorney on the 22nd.
Sir,
And
I'm sorry. You're on the phone. I can't hear what you're saying.
okay, can you hear me better now? Can you hear me better now?
Sir, my question to you is, are you a licensed
Yeah.
attorney in the state of Michigan? If the answer is no, I can't allow you to represent someone else.
Okay. I was just calling in to just say that he's trying to get his sugar down, and,
Sir, I'm going to keep saying, I can't hear you because I'm in a courtroom and you're on the phone and it's not coming
Yeah.
through clearly. Ms. Banky, have you had any contact from your named defendant?
I have not. I know my named defendant has been in discussions with my client, and I reviewed the Register of Actions, and I saw that the last time at the first hearing, the defendant said he had an attorney. I did some calling to the attorney. I spoke with him yesterday. He represented to me that he was not formally retained and the counsel would not be appearing today.
This court, in reviewing the file yesterday afternoon, did not see an appearance for an attorney on behalf of the named defendant in this matter. Ms. Banky, how would you like to proceed?
Your Honor, at this time, we are respectfully requesting that a default judgment for possession be entered in favor of the landlord tenant and against, in favor of the landlord, Premium Homes, and against the tenant. There is currently 3 months of rent past due. The monthly rent is $15,000. I'm sorry, there's 4 months past due because it was 3 at the time we filed and then March came due. And the monthly rent is $15,000 per month times
15,000?
Yes. Because this was a deal where the landlord.
Ma'am, no, it's fine. I don't care what the underlying deal is. I just want to get the right number so I know what to expect on whatever it is that you file for a judgment. 15,000 for 4 months, 60,000 plus the cost is what?
The cost of the filing fee was $55. And I have my my mailing fees that I paid 2 mailing fees to the court. And I had my own service of process fees, which I had it in my hand, and now of course I don't have that. So it was 55 plus 2 mailings from the court. And I'm looking at the Register of Actions for that.
Ma'am, let me say this. This case was scheduled at 9 o'clock. It's now 9:20. By this court's clock, the court has not received any appearance for an attorney representing the named defendant. I'll make a note in the file that James Nemeth appeared, but he is not a named party and he's not a licensed attorney in the state of Michigan. Based on that, the court will grant the default judgment for the $60,000 in past due rent that you just placed on the record, along with all recoverable court costs. That's the filing fee, the court mailing fees, the posting that was done at the property, etc. Submitted by on base, ma'am, and the court will sign it. I will note that this court has not received any information from the named defendant about his failure to appear. Sir, you're interrupting me. How can I help you?
I'm sorry. Apologies. So she sued for 45. Why is it 60 when it's 45 on the thing there? We haven't went over another month. So she's got 60. It was 45. So she said 60.
Sir, are you a signer to the lease?
No.
Okay.
I just don't know what.
Then sir, respectfully, sir, you're here as an observer. If you're not a named party, if you're not obligated under the terms of the lease or whatever the rental agreement is, I'm going to ask that you stop interrupting these proceedings. If the named defendant wants to make himself available to this court, he had every opportunity to appear this morning, or if he was not going to be available, he knew about today's date and he should have made efforts to be in contact or communication with the court's civil department so that his failure to appear this morning would be treated differently. But the court will grant the default judgment. Ms. Banky will present it to the court for entry. Copy will be mailed to Mr. Nemeth at the address we have on file. That concludes this matter. You're free to go. You have a good day.
Thank you, Honor. I appreciate the court's time and attention.
Thank you. This is 240-11790T Woodside Square versus Rashonda Johnson.
May it please the court, Mark Wasbury on behalf of plaintiff.
Ms. Johnson. Mr. Wasbury, this case was scheduled at 9 o'clock. It's now 9:22 by the court's clock. I'm just checking the court's breakout sessions to make sure that we don't have a Johnson. Last call for Rashonda Johnson. Defendant having failed to appear, sir, how would you like to proceed?
Judge, we are requesting a default judgment of possession only. The rent to retain possession is $3,052. Court costs are $180 for a total of $3,232.
Thank you. Please submit your default judgment through On Base. I will sign it. Anything else this morning in this case, Mr. Wasbury?
No, thank you, Judge.
Thank you, sir. Have a good day.
You too.
Mr. Horan, have you spoken with your tenants that are here for the 9:15?
I have not, but I also don't see anybody in the Levine waiting room, Your Honor, other than Ms. Samples.
I see Ms. Dixon
I
here in the
came
main
back.
session. I see Ms. Wilson here in the main session.
Okay, I don't move people from the main session generally, so if I don't see them in the waiting room, I
That's okay.
I realize that.
That's okay. Give me one moment. Ms. Wilson, did you have the opportunity to speak to the representative from Lakeshore Legal Aid?
Yes, I did. And I was also wondering if I could request to speak to Park Estates attorney.
Yes, ma'am. That's why I asked, what happened with Lakeshore? Are they going to be providing you assistance in this matter this morning?
So like I told them, I've lived in the state of Texas since November. I paid my November's month. I sold the trailer to another man. I told the park that I was leaving. I don't understand why they're still trying to come after me for non-paid rent.
So the answer to the question, ma'am, is no. Lakeshore is not going to provide you assistance this morning.
I don't know what they are. I thought that was my
Did-
attorney. I needed help with an attorney.
Okay. You sent a message asking, could you get assistance from an attorney? So I
Yes.
put you in with Lakeshore Legal Aid, who provides assistance to tenants. Did you talk to somebody from Lakeshore Legal Aid?
Yes, and they told me to request to speak to Park Estates attorney.
Thank you. We will get you moved in with Mr. Horan. The other tenants that are here for Levine will be moved into the Levine waiting room to speak to Mr. Horan. When you come back out, your case will be called. Thank you.
Thank you.
Judge.
Good morning.
I'm sorry, and just give you guys a heads up on this. She came in. She's in there. And he came in right behind her.
Who is he? The other defendant?
It looks like her husband. Well,
Okay.
that's what I was getting at. So she stops at the front, says, he's not supposed to be here, but he's. He isn't. Well, I told her, I don't run the courtroom. I can't, this is a public building. I can't stop people. No.
Mr. Devlin, are you done at Oakland Circuit?
Yeah, I'm out of Oakland Circuit.
Okay, Ms. Holt, do you need to speak to Mr. Devlin?
Yeah. Right, they're on the same team. It's obviously gonna want the same last name.
Ms. Holt?
I'm sorry, I had to try to unmute my phone. I
That's
did
okay.
everything that I told them I was gonna do the last time we spoke, so I guess we could speak for a second. Just to
Okay,
catch
you'll
up.
see an invitation go into the breakout room with him.
Okay.
Thank you.
They have the same last name.
Right.
Her her subpoena says, be here in person. His says Zoom.
Because she asked to appear in person?
I don't know.
No, I'm telling you, because last time we were here, she was in our Zoom room and she indicated that she wants to be in person. I can't make somebody appear on Zoom who wants to be in person. So I told her she could come. Whether they're on Zoom or in person, we'll see them. I know that you all are busy because it's Wednesday, but it's still early enough where you shouldn't be. Okay.
Yeah, we're fine. You just let me know when you want me to bring them in.
I will. It's Mr. Horan's office and he just went in with somebody else. Are you staying up here or are you downstairs? Okay. If you stay up here, I'll call you when I get a minute.
Okay.
I'm looking and there's. If you just answered the question, these will go so much more quickly.
I know.
You've had all this time to get ready. Could you help me a little bit? I knew about that case. I knew she was coming in person. And we'll get to them as
Okay,
quickly
so
as we
I'll
can.
just wait out here for your phone call.
I'd appreciate that.
Okay.
Thanks. And if Mr. Brooks hasn't already been in with the Levine's office, we'll get them moved in. Same with Ms. Stamps. Anybody who's here for for Levine's office, we can get them into the waiting room to speak to Mr. Horan. Mr. Morton.
I was gonna ask Mr. George if he has someone available to speak with the moods. And I would just speak with Mr. George or whoever would speak with the moods very briefly beforehand, Your Honor.
Thank you.
Mr. Morton, I would ask that you address that question to Patricia Pruknick. She is in the driver's seat today with Zoom.
Okay. Patricia, did you hear that question?
I did. I'm not used to having co-host powers. I didn't realize I had that. Yeah, that would be fine.
Who would be the best person to be able to have them speak with? And I was going to talk to that person just briefly beforehand.
Let me see who we still have here today.
I can volunteer for that part at least.
Oh, okay. Then yeah, it'd be Mr. George.
Okay, George, do you have co-host capabilities?
I do not, but Patricia can throw us into a breakout room.
Okay. If you want to, I mean, I have it too, but if you want to pick which one you want to put us into, and then I'll speak to Mr. George real quick, and then you can speak to the moods.
Two 401-128 LT Propel Property versus Tiffany Holt.
Your Honor, Adam Devlin, P72877 for the plaintiff. Your Honor, I don't see that she's rejoined the main room.
I know, let me. Mr. Devlin, did you scare her off?
I hope not.
Here she is. Ms. Holt, would you state your name for me, please, ma'am?
Tiffany Holt.
Thank you. Today is the day and time scheduled for the second hearing of this matter. The parties have had the opportunity to speak. Mr. Devlin, how are we proceeding?
Your Honor, the only rent that she has due and owing is March's rent. She's made payments during the pendency of this action. Currently, we agree that currently due and owing inclusive of costs is $1,080.84. And she's going to have that paid by the 29th. Legally, the judgment will say the 1st of April.
Legally, the consent judgment or some other type of
Yes.
judgment, sir?
Consent judgment. Yes.
Thank
Sorry,
you.
Your Honor.
Ms. Holt, were you able to hear Mr. Devlin just now?
Yes, ma'am.
And ma'am, is it true and accurate that there's $1,080.84 in rent and court costs due and owing in this matter?
Yes, Your Honor.
And ma'am, you wish to enter a consent judgment with those terms that you will pay this amount or vacate by April the 1st?
Yes, Your Honor.
And Ms. Holt, you were here on March the 7th and saw a video that explained the legal rights you have available to you in this matter.
Yes, ma'am.
Do you have any questions about your legal rights?
No, not at this time.
Do you have any questions about the consent judgment that will enter?
No, Your Honor.
Then Mr. Devlin will have his office prepare a consent judgment with those terms. Because you appear by Zoom, there's not a signed consent. Did you authorize Mr. Devlin to sign your name to the consent judgment?
Yes, Your Honor.
Then he will prepare it, sign it with your signature, his signature submitted to the court through OnBase. I will sign it and a copy will be mailed to you at the address we have on file. Anything else in this case, Mr. Devlin?
No, Your Honor.
Anything else, Ms. Holt?
No, Your Honor.
Ms. Holt, thank you so much for your patience today. You have a good day. You're free to go.
Thank you. You do the same.
Thank you. 2401126 LT Propel Property versus David Booth.
Your Honor, Adam Devlin, P72877 for the plaintiff.
Mr. Devlin, the last time we were here, you asked for entry of default judgment. The court did advise that there were no proofs of service. It appears that service has now been made upon
Correct, Your Honor.
Mr. Booth with notice to appear this morning at 9 o'clock. It's now 9:31 by the court's clock. David Booth, no response. There being no unidentified persons in this court's main session or any of the breakout rooms. How would you like to proceed this morning?
Your Honor, this time I'd actually like to have a default judgment entered. Currently due and owing is $1,397.95 in rent, $165.04 in costs. Total is $1,562.99 for a date of the 1st of April.
Thank you, sir. Please present that through OnBase. The court will sign it. Anything else in this matter?
No, Your Honor, and that's it for me today. Have a good week.
You too, sir. Thank you. Mr. Lubansky, Ms. McLemore was waiting to speak to you. Let's get you relabeled as a co-host and you can get into a breakout room with her.
Great. I am co-host.
Thank you, Your Honor.
Sandy, my only concern is that Mr. Horan has quite a number of people. I don't know if he needs his clients with him, if they need to go into breakout rooms of their own. We're just starting to drag a little bit already.
Yeah, you want me to go in there and ask him or see if he wants to come out and get what he has done? I don't believe he's spoken with anybody but the Haley Wilson.
We'll leave him for just a little bit, because we don't have a heavy docket. I'm just concerned. We'll work around him for as long as we can.
Okay.
Thanks.
Uh-huh.
Two.
Are we ready with Black and McClendon?
Yes, Your Honor.
Yes, Your Honor.
This is 2401110 LT Swan Creek versus Bernard Black and Kamisha McClendon. May I have your appearances, please?
Alex Lubianski, P77121 on behalf of plaintiff.
And Danette McLemore of Lake Shirley Grade on behalf of the defendant, Ms. McClendon. And I believe Ms. McClendon is present on the Zoom.
No response from Delinda Harris, nor any resident of 892.
I did see her.
She had been here.
Yeah, I saw
I
her
don't know.
before. Here now.
Why is she in? Yeah, she was in a breakout room with the wrong people. The parties have had the opportunity to speak. How are we proceeding, Ms. McLemore?
Your Honor, I have had an opportunity to speak with a counsel for the landlord, and we have agreed that there shall be a consent judgment that will be entered, and the defendant, the total amount of the judgment would be $2,181.40. Of that, $1,961.08 is rent and $220.32 is court costs. The defendant shall have until April the 1st to pay that amount in full. And if that amount is satisfied, that the defendant's counsel will prepare a stipulation to set aside the judgment and dismiss and can present that to plaintiff's attorney, and this case would then, as long as it's satisfied and paid, this case would be, the judgment will be set aside and the case dismissed.
Is that your understanding and agreement, sir?
Yes, Your Honor, that is correct.
I'll make a note in the file that the court will be expecting a consent judgment with those terms. Anything else on behalf of the plaintiff?
Nothing further, Your Honor. I'll submit that today.
Thank you. Thank you, Ms. McLemore.
Thank you, Your Honor.
And then we have 2401120 LT Swan Creek versus Nancy Boyd.
Alex Lubianski, P77121 on behalf of plaintiff.
We
My name is
have
Sarah
Ms.
Boyd.
Sarah Boyd here, who's the, sorry, go ahead, ma'am.
I'm the niece of Nancy.
She was here originally with the indication that the Ms. Nancy Boyd was in a nursing home since August of last year. And I believe either your office or a representative from the Swan Creek had a conversation with her last week. Mr. Lubianski, do you have any information about the status of this matter?
I'm still showing an amount due and owing, Your Honor. As of today's date in rent, that is $1,362.70. Court costs of $177.66 for a total of $1,540.36.
Thank you. Ms. Boyd, was there anything that's changed since the last time we were here?
Yes, the nursing home has deemed her incompetent to make her own decisions. My husband's medical power of attorney has been put into effect. And we are working with a lawyer to obtain conservatorship over her.
Okay, ma'am, that might change the status of things with the nursing home and going forward, handling her matters, but it doesn't change these landlord-tenant proceedings. And as indicated when you were here the last time, I cannot allow you to represent her interest in this matter. There is notes in the file regarding the reason why she may not be present, but she is not here. This case was scheduled at 9:30. It's now 9:43. Based on her failure to appear, the court will enter a default judgment that shows the past due rent of $1,362.70, $177.66 in court costs for a total of $1,540.36. Mr. Lebansky's office will present that default judgment to the court. I will sign it, and the copy will be mailed to the address we have on record. Was there
Very good.
anything
Thank you,
else
Your
on
Honor.
behalf of Swan Creek? Thank you. Ms. Boyd, thank you for your assistance in this matter. Like I said, I'll make notes in the file regarding the change in her status with the nursing home.
Okay, thank you very much.
Thank you, ma'am. Have a good day.
You too. Thank you.
Your Honor, for the interest of efficiency, I just received an email from Swan Creek in regards to Corkery and Well Day, and I will be filing a dismissal.
Thank you.
Thank you, Your Honor.
Just so the record is clear, that's 2400700T, scheduled at 9:45. There's a notation that dismissal is forthcoming.
Thank you.
Thank you.
Case number 24C06.
Oh, no, we need to pick up the pace on this. Ms. Panko?
Yes, yes, ma'am.
Ma'am, did you make payment to West Village Estates?
No, I applied for SCR.
Your Honor, I'm representing Ms. Pankow. I did just notice her case had been dismissed.
That's what I was about to say. I don't have an appearance from you, ma'am, but Ms. Pango, the court has received a dismissal of this case.
Okay.
That means you're free to go unless you just want to stay and hang out for a little while.
No, thank you.
Have a good day. Mr. Morton, any update?
I just spoke to Mr. George. I was going to, I think he has, I will pull them back in the main. Here we go. The mood should be entering shortly, Your Honor.
Thank you. This is a recall of 2401100 LT Rawsonville Woods versus Mood and Mood.
Your Honor,
How
for
are
the
we
record,
proceeding, Mr. Morton?
Your Honor, there was it the party spoke beforehand. They had an opportunity to be able to speak with legal aid as well. Was it, from my understanding, we'll just confirm this on the record. Parties have agreed to a vacate date of April 5th, 2024. This will be entered as a conditional dismissal. This is a non-renewal termination. Therefore, it is just a straight move out. So as long as both parties move out on or before the 5th, which, as I told them also, the 5th is a Friday, which means the next business day would be the 8th. So they do have those additional 2 days during the weekend that my client could not take any action. So if they receive possession before the 8th, that would also mean the case would stay conditionally dismissed. I did advise them of their rights to be able to, the fact that this agreement would not be final for 3 business days, which is one of the reasons why it triggered for their opportunity to be able to speak with legal aid again. 2, I did advise them of their rights to be able to seek, to appeal this matter. And then 3rd, I believe I have it, and we'll just confirm again, I have permission to sign their name to the proposed conditional dismissal with the April 5th move out date.
Mr. George, are you appearing in this matter or was it just advice?
Mr. George was giving them advice, Your Honor.
Thank you. Mr. Mood, were you able to hear Mr. Morton just now indicate that there will be a conditional dismissal of this matter? That indicates that you will vacate by on or before April 5th of 2024.
Yes. Yes.
And that's what you wish to agree to?
Yes, we don't have a home. We just to go to. This is going to render us homeless. But we have made efforts to have a place to put our belongings in storage. So we do feel that we can commit to that move out date.
Okay. And you were present on March the 7th and saw the video that explained the legal rights you have available to you in this landlord-tenant proceeding?
Yeah, we saw the video. It went by very quickly. It went by very quickly, and we don't really have any means of acting on any rights that we might have anyway. So we were hoping for whatever extension of time that we could, in the hopes that a home might open up, that we might find a place to live, but have taken steps in order to be able to vacate, even if we don't have a place to live.
Okay.
Sorry for taking so many words.
No. It's perfectly fine, sir. Do you have any questions about the conditional dismissal that will enter in this matter?
I don't believe so. I believe our understanding is that if we're able to turn over the keys by the 5th or essentially the 8th of April, we will be able to avoid having a eviction judgment on our records of our personal lives, and we will find a mover to help us get out of here under those conditions.
Then Mr. Morton's office will prepare the conditional dismissal that indicates that you'll vacate by April the 5th He'll sign your name to it, submit it to the court. You should receive a copy from me once it is signed. Is there anything else, Mr. Morton?
No, Your Honor.
Anything else, Mr. Mood?
I don't believe there's anything else. We have agreed to allow him to sign that agreement, and we understand April 5th is our move out date. With a, technically it turns into April 8th, but we've agreed to that. Yes.
Then I will await receipt of that document from Mr. Morton. That concludes this matter, Mr. Mood. Thank you for your patience today. You're free to go. You have a good day, okay?
Thank you very much.
Thank you, Your Honor.
You're welcome.
Yes, thank you, please. Appreciate it.
You're welcome.
Hope
Have a
your
good
day
day,
goes
sir.
well. Yes, thank you.
Thank you.
Is it time for us to, can we hang up now?
You may hang up now. Thank you.
Thank you.
Ms. Austin, did you have the chance to speak to Zakia Purnell?
I have not, Your Honor.
Let's get you moved into a breakout room with her.
Thank you.
Second, I'm gonna, oh,
I'm sorry to interrupt you, Mr. Horn, but I just want to get these people cleared off the screen and figure out how we can
Sure.
get this docket moving a little bit faster. This is 2401189 Trilogy Residences versus Goliath. May I have your appearances, please?
Danny Horn, P 1774 for plaintiff.
Your name, sir?
Chicago's.
Thank you. This is the second hearing. The parties have had the opportunity to speak. How are we proceeding?
Your Honor, we have a consent judgment for possession with rent to retain of $6,311.77. Cost of $181.68 for a total of $6,493.45, payable on or before April 1st of 2024. I informed them of their rights as an unrepresented party and did ask for and got permission to sign the agreement and add their name as well and submit to the court.
Thank you. Sir, were you able to hear Mr. Horn just now?
Yes, ma'am.
And it's your understanding and agreement that a consent judgment will enter that shows that you owe a total of $6,493.45?
Yes, ma'am.
And you were present back on March the 7th and watched the video that explained the legal rights you have available to you in this matter.
Yes, ma'am.
Do you have any questions about your legal rights or the consent judgment that will enter?
No, ma'am.
Then Mr. Horn's office will prepare that consent judgment with the terms just placed on the record submitted to the court electronically. I will sign it and the copy will be mailed to you at the address we have on file. Other than that, sir, you're free to go. You have a good day.
Thank you, Judge.
Thank you. This is 2401194 LT Park Estates versus Haley Wilson. Mr. Horn, I see your appearance. The other parties, please state your names for the record.
Haley Wilson.
John Michael Ross.
Thank you. Today's the day and time scheduled for the second hearing in this matter. How are we proceeding?
Your Honor, we have a possession consent judgment, and this one is a little unorthodox, but we're going to remove Ms. Wilson's name as a named defendant. This consent judgment will be for all occupants only. The terms will be as follows: rent to retain, $2,503.89, cost of $181.68, for a total of $2,685.57, payable on or before April 1st of 2024. Additionally, that must be paid by certified funds, as well as on or before April 1st, 2024, the occupant, John Michael Scott Ross, will submit and complete an application for residency to the plaintiff. If he does that and is approved, then they can enter into a new lease. If he does not complete that application on or before April 1st of 2024, that would be considered a default and a writ could issue as well.
If you're dismissing the named tenant, who's signing the consent judgment?
Ms. Wilson is signing. We simply don't want it to reflect on as any judgment against her.
She's signing an agreement that binds somebody else to apply for residency?
Mr. Ross is currently in the property. He's not been approved. He's also here and agreeing as well. We had a breakout room where he spoke and agreed to do the application as well. He's an occupant
Mr.
currently.
Ross, were you able to hear Mr. Horn just now?
Yes, ma'am.
And is everything he said true and accurate?
Yes, ma'am.
Ms. Wilson, do you have any questions about the rights available to you in this landlord-tenant proceedings or the consent judgment that will enter?
The only question I have is what happens after April 1st if he does not proceed with what he's supposed to do?
He's deemed in default, ma'am.
All right, then no, ma'am, I have no more questions.
Thank you. Mr. Ross, do you have any questions?
Just the rental assistance, how do you do that? You know?
Sir, that was included in the service of the summons and complaint that you received in this matter, or if you don't have your copy of your advice of rights anymore, you can go onto the court's website, look under the civil department. There's information there about resources that might be available to help you with rental assistance in this case, okay?
Sounds good.
Your
Thank
Honor,
you.
just the
Other
final
than that,
piece-
Mr. Horn's office,
I apologize, Your Honor. I just wanted to make sure that on the record, we had permission from Ms. Wilson and Mr. Ross just to add their names to that agreement.
Yes.
My question is, does she have to be added? Because I really want her, no offense to you, Haley, I want to take care of you first and get you off the lease because it's not right what happened. So that's my biggest concern is getting you off the lease. So does that help us, or does that like bind us together still?
it doesn't bind
No,
you
that- I'm
together.
asking
His
for-
question was, does he have your permission to sign your name?
Oh yes, I'm sorry. Yep. Sorry.
Okay. No worries. Then that concludes this matter. You're free to go. Thank you for your patience this morning.
Thank you. I appreciate your guys' help.
This is 2401212 LT West Village versus Willie Brooks.
Willie Brooks is here, Your Honor.
Turn your video on, sir.
Yes.
Thank you. Today is the day and time scheduled for the second hearing in this matter. Mr. Horn, how are we proceeding? You're muted, Mr. Horn.
Your Honor, there remains an outstanding balance of rent, $1,544.32, with cost of $181.68. The total is $1,726. We'd ask for a possession judgment in that amount.
Thank you. Mr. Brooks, were you able to hear the amount just placed on the record by Mr. Horn?
Yes, ma'am.
And is that amount accurate?
Uh, uh, yes, Your Honor.
Okay, Mr. Brooks, you were present when there was an advice of rights video played back on March the 7th. Do you have any questions about the legal rights you have available in this case?
No.
And sir, inasmuch as you admit and acknowledge the amount of rent claim due and owing by the plaintiff is accurate, there's not a tribal issue of fact, and plaintiff is entitled to entry of judgment in the amounts that Mr. Horn just placed on the record. His office will prepare a judgment that reflects those amounts. He will send it to me electronically. I will sign it and a copy will be mailed to you at the address we have on record. Do you have any questions about today's proceedings, Mr. Brooks?
Do I have to the end of the month to pay it?
You have 10 days from today's date to pay it, sir.
That's what I need. Okay, then, yeah. 10 days from today.
Anything else, Mr. Brooks?
That's good for me, Your Honor.
Okay. Then other than that, Mr. Brooks, you're free to go. You have a good day.
Enjoy your day, Your Honor.
Thank you. This is 2401214 LT, West Village versus Irma Dixon Ward. Ma'am, state your name for the record, please.
My name is Irma Dixon Ward.
Ms. Ward, the last time we were here, you indicated that you made an application for rental assistance. The court did receive form from you indicating that you made that application. What's the status of your request for rental assistance?
She said first she denied me, and then she sent me a letter yesterday and told me she needed more documentation. So I don't know, but anyway, I'm still working on it. But I just need a little bit more time, and then I'll have it paid.
What's a little bit more time?
Probably till I plan on having to pay before the 1st, because the rent will be due all over again. Definitely before the 1st.
Mr. Horn, what's the rent to retain?
Your Honor, rent to retain $2,382.70. Cost of $181.60 for a total of $2,564.38.
Ms. Ward, are the documents requested only documents from you, or do you need documents from your landlord as well?
No, she needed more documents because one of my child just turned 18. So she needed documentation that the adoption was over. And the guy just emailed it back to me like Friday, and I asked him a week ago for that information. The state of Michigan.
Ma'am, inasmuch as your application for rental assistance remains pending, you are entitled to the continuation of the stay in this matter. I'm just looking for a date, Mr. Horn. Sandy, what is April 2nd?
That is your civil docket.
I just don't have it up.
Tuesday, yeah.
For a time.
I think 9:30.
Ms. Ward, we'll continue this matter till April 2nd at 9:30.
Okay.
Mr. Horn's office will be looking for entry of judgment at that time, so please come with an update for your rental assistance application, and we'll have a discussion about how to proceed at that time, okay?
Right, but 9 times out of 10, if they don't give me an answer by next Wednesday, I'm just gonna have to come up with it because I don't want to go into another month. I own my home.
Understood. I'll see you on April 2nd, ma'am. Have a good day.
All right, thank you. Goodbye.
Thank you. Mr. Horn, if you want to go back into your breakout room, please do so. I'm just trying to get us moving. You have Ms. Askew is here in person in the court. The case was scheduled at 9:30.
Understood, Your Honor. Thank you.
Thank you. 2401556 LT Willow Glen versus Danielle Reinhardt. May I have your appearances, please?
Good morning, Your Honor. John Coslin, representing Willow Glen.
Good morning.
Your Honor, we've had an
State your name,
opportunity.
ma'am.
I'm sorry.
That's okay.
Danielle Reinhardt.
Thank you. Mr. McCausland, you were saying?
We've had an opportunity to meet in a breakout room beforehand, and we're prepared to put the terms of a consent judgment on the record. Those terms are that the current rent to retain possession is $1,400. The court costs are $191.93 for a total amount due of $1,591.93. It's agreed that Ms. Reinhardt will pay that amount or vacate by April 2nd. She has given me her consent to sign her name to the judgment. She has been advised that if there's an error, she has 3 business days to file a motion with the court seeking relief, as well as she has until April 2nd to file an application, to file an appeal of this matter, the Wayne County Circuit Court. Again, the amount due of $1591.93 is inclusive of the March rent only and does not include any April rent.
Ms. Reinhardt, were you able to hear Mr. McCausland?
Yes, I was.
And ma'am, is your understanding and agreement that there's $1,591.93 due in past due rent and court costs?
Yes. I got.
And ma'am, you were, I'm sorry, what did you say?
I said I had assistance from the state. They agreed to pay $671 of that.
I can't hear you, Ms. Reinhardt.
I said I agreed to pay, my caseworker agreed to pay $671 by April 2nd if I have paid the $1291.
Okay.
Landlord said I owe, I'm sorry, $971 now.
And Ms. Reinhardt, you were here back on March the 13th when there was an advice of rights video played that explained the rights you have available to you in this landlord-tenant matter.
Yes.
Do you have any questions about the rights available to you?
No, I don't.
Do you have any questions about the consent judgment that will enter in this case?
No, I don't.
Then Mr. McCausland's office will prepare a consent judgment with the terms he just placed on the record. He will submit it electronically. I will sign it, and a copy will be mailed to you at the address we have on record. Is there anything else in this case, Mr. McCausland?
No, that's it, Your Honor. Thank you.
Thank you. Anything else, Ms. Reinhardt?
No, that's it, Your Honor. Thank you.
Ms. Reinhardt, that concludes this matter, ma'am. You're free to go. You have a good day.
Okay.
This is 2401484 LT. This is Belleville Point versus Lacenta Hall and Zakia Parnell. State your names for the record, please.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Zakia Parnell. Parnell. I see you're in the main session, Ms. Austin. You had the opportunity to speak. How are we proceeding?
Your Honor, we do have the terms of a consent judgment to place on the record. Oh, she said she's trying to unmute in the chat. I was able to speak with her.
The terms of the consent judgment, ma'am?
Your Honor, there's rent to retain of $2,306.95. Court costs of $194.43. The total's $2,501.38. Ms. Hall is going to pay $1,000 by April 1. She's going to pay the remaining $1,501.38 by April 5. She told me that her rental assistance was approved for the amount of $500. So that second amount, she's going to pay $1,001.38, then triggering MDHHS to pay the $500 to complete that balance. She did give me permission to sign her name to the judgment. Lacenta Hall is not here, so I'd request a default with the same terms with regard to her.
Thank you. Ms. Parnell, I see your note that you're unable to unmute, but were you able to hear the attorney just now? And ma'am, you were present before when there was an advice of rights video played. Do you have any questions about the rights available to you? Then Ms. Parnell, I see your responses to my questions in the chat that you saw the advice of rights and you have no questions. Based on that, Ms. Austin's office will prepare a consent judgment with the terms just placed on the record. She will submit it to the court electronically. I will sign it and a copy will be mailed to you at the address we have on the record. A consent as to you and a default as to defendant number one, Hall. If there's nothing else, Ms. Parnell, you're free to go. You have a good day.
Thank you, Your Honor.
Thank you, ma'am. Mr. Katz, 2401517, Maxwell versus Elijah Nelson.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
State your name for me, please, sir.
Elijah Nelson.
Thank you. Today is the day and time scheduled for the second hearing in this matter. Mr. Katz, how are we proceeding?
Your Honor, I did not have an opportunity to speak with Mr. Nelson. I could let him, well, let me go into a breakout room. I'll pull him in. I keep on forgetting that you guys give me access. So let me pull him in.
This is 2401568 LT Holiday Woods versus Grinstead.
Your Honor, Attorney Ian Morton, Appellate's Law, on behalf of the plaintiff.
District Attorney Counter on behalf of Mr. Grinstead.
Thank you. Today is the day and time scheduled for the second hearing in this matter. How are we proceeding?
Your Honor, Mr. Grinstead has applied for SCR and the DC 539 form was filed.
I'm looking at our file to find out when that was actually filed, Your Honor, if it was filed within the 5 days or what the status of the application is, because I thought he was originally denied.
He has a pending one. The tracking number is T37.
I'm showing the 539 filed on 319.
Yes, Your Honor.
With a copy of the, let's look here. Application submitted. That being the case, Mr. Morton, we will put this matter over. I'm just looking for a time on April the 2nd. 1, 2, 3, 4. I'm looking at April the 2nd at 10:15 a.m. back on Zoom. And that would be the last day of these proceedings.
Thank you, Your Honor.
Anything else, Mr. Morton?
No, Your Honor.
Anything else, Ms. Brooknick?
Nothing further, Your Honor.
Thank you. Mr. Grinstead, I'll see you on April the 2nd at 10:15 a.m. Thank you, sir. Have a good day.
Thank you, you too.
This is 2401123 LT Swan Creek versus Roberts.
Alex Lubianski, P77121 on behalf of plaintiff.
Mr. Lubianski, my apologies to you. This case was scheduled at 9:45. It's now 10:17. Roberts. Today was the end time scheduled for the second hearing in this matter. Hearing no response from the defendant, how would you like to proceed, sir?
No need to apologize, Judge. Based on everything, we would move for a default judgment of possession only. Amount of rent currently due, $1,574.50. Court costs of $177.66 for a total of $1,752.16 with the writ date of April the 1st. To the best of my knowledge, the defendant is neither a minor, incompetent, nor are they in the military service, and the premises have been kept fit for their intended use. I will submit the proposed default via my file.
Thank you, sir. Anything else this morning?
Nothing further. Thank you so much, Your Honor.
Have a good day.
You as well.
Ms. Stamps, did you have the opportunity to speak to the attorney, Mr. Horn?
I did.
2401225 LT West Village versus Stamps. Ma'am, turn your video on. Did you reach an agreement with him?
Yes, I believe you just said to make sure. Well, just to give an update status, I was approved for the full amount, so they should receive the funds within the next 7 to 14 days, is what the email said, if I'm not mistaken.
Give me one moment. We'll get Mr. Horn back out here. Mr. Morton and Ms. Methner, were you ready on Lester?
Ready, Your Honor. That should be one where we have the DC 539 filed on Monday. So
this is 2401609 LT Harbor Club versus Lester. I am showing that 539 being received.
Hello.
Thank you, Ms. Lester. That being the case and the status of the request for rental assistance remaining pending, Mr. Morton will put this matter over to that same April the 2nd at 10:15.
Understood, Your Honor.
thank you.
Anything else, Ms. Methner?
Not on this case.
Thank you. Ms. Lester, I'll see you on April the 2nd at 10:15. Court staff will mail you notice of that new date and time. Have a good afternoon.
Thank you so much.
It's a recall of 2401517 Maxwell versus Nelson. Mr. Katz, how are we proceeding?
Good morning, Your Honor. I'm going to be submitting a dismissal on this one.
Thank you. Mr. Nelson, were you able to hear that?
Yes, ma'am.
Case will be dismissed. You're free to go. You have a good day.
Thank you. You too.
Thank you. 2401520 OT Maxwell versus Deron Wiggins.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Wiggins. Mr. Katz, I'm looking and I don't see anyone by that name. Any of the court's breakouts. There are no unidentified persons in this court's session. The case was scheduled at 10 o'clock. It's now 10:22 by the court's clock. Defendant having failed to appear, how would you like to proceed?
Your Honor, at this time requesting a default judgment. This is a second hearing for non-payment of rent possession only. Currently, there's a balance due of $586 of past due rent, $170 of cost for a total of $756. Requesting a default judgment in that amount with the writ to be issued after April 1st.
Thank you, sir. Please submit your default judgment.
Thank you, Your Honor.
This is 2401524 LT Maxwell versus Angela Williams.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Angela Williams.
She should be back here, Your Honor. We did talk.
I know she was here earlier. I'm looking for her. Mr. Katz, I'm not getting a response, and this case was scheduled at 10:15. It's now 10:23 by this court's clock. How would you like to proceed?
Your Honor, I did have a discussion with Ms. Williams. We did go over her balance. We did enter into consent. This is a non-payment rent possession only case. There's currently a balance of $2,842 of past due rent, $170 of costs for a total of $3,012. I did advise her of MCR 4.201. She has until April 1st to pay that amount, and she authorized me to submit it to the court with her verbal authority.
Respectfully, Mr. Katz, she's not here. If she comes back on, I will inquire and take it as a consent. Other than that, I will need to take it as a default. I did note her appearance earlier. I'm not sure what happened.
Okay. I mean, she's getting the same amount of time, so I'll submit it as a default.
Thank you, sir. Two 2401526 LT Maxwell versus Lynetta Bohannon.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Good morning, Your Honor.
Good morning, George. George of Lakeshore Legal Aid on behalf of Ms. Bohannon, who is present.
Thank you. How are we proceeding this morning?
Your Honor, we did have a discussion. I did speak with Mr. George. There's currently, this is a non-payment rent possession only case. There's currently a balance due of $1,155 of rent, $170 of costs for a total of $1,325. Ms. Bohannon's going to have until April 5th to pay that amount. This is a consent judgment. We did agree that if Ms. Bohannon pays or moves out prior to the writ being issued, a motion to set aside will be, or a stipulation would be agreed to if presented.
Is that your understanding, Mr. George?
Yes, it is, Your Honor.
Thank you. I'll make notes in the file that that's how we're proceeding. Anything else, Mr. Morton? I'm sorry, anything else, Mr. Katz?
Your Honor, Mr. George is going to prepare that and send it to me for review.
Oh, okay. Anything else, Mr. George?
Nothing further, Your Honor.
Thank you. Ms. Bohannon, you're free to go. You have a good day. Good luck to you.
You as well, Your Honor. Thank you.
And Ms. Bohannon, if you have any questions, give me a call, okay?
Will do. Thank you.
You're welcome. Thank you.
Thank you. Have a good day, Your Honor.
You too, Mr. Katz. This is 2401225 LT West Village versus Stamps.
Good morning again, Danny Horn, P81774 for plaintiff.
Good morning.
Good morning. Mr. Horn, how are we proceeding?
Your Honor, we got a notice that Ms. Stamps has been approved for assistance just this morning. So we would ask for an adjournment of roughly 2 weeks to give them the opportunity to hopefully get a pay date and get it paid before the next hearing.
That day will actually be April 2nd at 10:30 a.m.
Right.
Notice will be mailed to you at the address we have on record, Ms. Stamps, and if If it's paid before that time, Mr. Horn will update the court. Anything else, Mr. Horn?
Nothing further.
Anything else, Ms. Stamps?
No,
Ma'am, you're free to go. You have a good day.
thank you too.
Thank you. This is 2401192 LT Huron Estates versus Keith Dyer and Harvey Fry Jr. Names for the record, please.
Danny Horn, P 1774 for plaintiff.
Keith Dyer,
Yes, ma'am.
state your name for me, sir.
Keith Dyer.
And where is Harvey Fry?
He's not in the country right now.
Okay. Mr. Horn, how are we proceeding?
Your Honor, Mr. Dyer and plaintiff have come to an agreement on a consent judgment. It'll be a default judgment as to Mr. Fry with the same terms for possession. Rent to retain, $3,790.35. Cost $231.71 for a total of $4,002.06. Payable on or before.
I'm sorry. Mr. Horn, 4,000.
$4,022.06. Payable on or before April 1st, 2024. I did indicate their rights under MCR 4.201. Mr. Dyer, I asked for and was given permission to add his name to the agreement with the terms I just put on the record.
Mr. Dyer, were you able to hear Mr. Horn just now?
Yes, ma'am.
And sir, you were present back on March the 7th and watched the advice of rights video.
Yes, ma'am.
And sir, do you have any questions about the rights available to you in this landlord-tenant matter?
No, ma'am.
Do you have any questions about the consent judgment that Mr. Horn just placed on the record?
No, we agreed to have it paid by April 1st, so.
Thank you. His office will prepare a consent judgment with the terms just placed on the record. He will submit it to the court through electronic filing. I will sign it and the copy will be mailed to you at the address we have on record. Anything else, Mr. Horn?
Nothing further.
Anything else, Mr. Dyer?
No, ma'am.
You're free to go, sir. You have a good day.
Thank you, you too.
Thank you. This is 2401217 LT West Village Estates versus Kayla Johnson.
Danny Horn for the plaintiff.
Kayla Johnson,
Your Honor,
this case was,
Sorry.
you go ahead.
Oh, it's possible Ms. Johnson's not here today. She just paid in full this morning, so that might explain why she's not here. And I just wanted the court to know we'll submit a dismissal. I didn't mean to interrupt you.
No worries, Mr. Horn. Thanks for the update. We'll make a notation that this case is dismissed.
Thank you.
This is 2401594 LT. This is Belleville Manor versus Tennis, Baldry and Tennis.
Danny Horn for the plaintiff.
Oh, Cindy Boudre.
Michelle Tennis.
And Ryan Tennis.
Thank you. How are we proceeding this morning, Mr. Horn?
Your Honor, we've come to an agreement on a possession consent judgment with rent to retain $2,060.20. Cost $281.74 for a total of $2,341.97. Payable on or before April 1st of 2024. Did explain their rights under MCR 4.201 as unrepresented parties, and all three of the defendants gave permission to add their names to the agreement with the terms I put on the record.
Thank you. To Ms. Tennis, Baldry and Tennis, you were present on March the 13th and you watched the advice of rights video that explained the rights you have available to you in this landlord-tenant matter?
Yes, ma'am.
Did you have any questions about the rights available to you?
No, thank you.
You heard the attorney place on the record that there is a total due of $2,341.97, which is past due rent and court costs?
Yes, ma'am.
And you wish to agree to entry of a consent judgment with that amount?
Yes.
Do you have any questions about today's proceed?
Yes.
Go ahead.
I applied for an SCR. They denied it because they said I had self-employment, but I don't have self-employment. I actually work at a Gilbert residence. And so they told me to go back to court today and get a judgment and then refile for the SCR.
Then what will happen next is Mr. Horn's office will prepare a consent judgment with the terms that were just placed on the record. I'll sign it and a copy will be mailed to you, and that will give you the document that you indicate that you need to make reapplication, okay?
Okay.
Anything else, ma'am?
No, that's all. Thank you.
You're welcome, ma'am. Good luck to you.
Thank you. Thank you.
Oh, boy. Oh. 2401591 LT, Belleville Manors versus Bella Jones and Damian Hulslander.
Danny Horn for the plaintiff.
Yes, Your Honor.
State your name for me, sir.
Damian Hulslander.
Thank you. Mr. Horn, how are we proceeding this morning?
Your Honor, we're requesting a possession default, or excuse me, a possession judgment with rent to retain of $1,382.05, cost of $231.71, for a total of $1,613.76, payable on or before April 1st, 2024.
Mr. Hulslander, were you able to hear the amount of past due rent being $1,382.05?
Yes, ma'am.
Is that amount accurate, sir? I'm sorry, go ahead.
Yes, Your Honor. I've been making payments on, I spoke to the last attorney. It was a different attorney. And I've been making payments on it every week. And this week I just got a new job. So I've got to wait. This Friday I won't get paid, but next Friday I will. And I'll pay double. This job's a lot more money. I had to switch around jobs. I lost a job. So then I got another one that wasn't paying right. And it's the first time I've been late in 3 years. So I'm not trying to, that's why I'm not trying to go on to a payment plan. I know I can bounce back. I just had a rough time, a little rough patch. The mold in the house, it's hard. My girlfriend, she has got COPD, so she can't live in this house right now. And it's been 10 months since they ain't fixing it. They just keep sending different contractors and stuff. So it's hard being one person at the house, having to do all that. I'm trying my best. I'm paying every week. I'll have a payment coming sometime next week. Like I said, I just started a new job this week.
Sir, I understand and I respect that. The question is the amount of rent that he's claiming is due accurate?
I said that. I already said that. Yes, it's accurate.
Okay.
Absolutely.
Okay.
And I'm trying my hardest to get it paid in the time that it's due, but I'm not I can't say for sure right now if it's going to be, like I said, because I'm not 100% of what my check will be with this week and next week in it. Because this week I had to call off today too to take to do this. He wouldn't let me do it on the phone. My last boss did last week or the 2 weeks ago.
Then, sir, what the court will need to do, because you admit that the amount that Mr. Horn has placed on the record is accurate, there's not a tribal issue of fact, and the plaintiff is entitled to entry of judgment in the amount that he's requested. He will submit it electronically to the court. It will indicate that you have 10 days to pay or vacate. But if you already have some conversation you've had with.
What was that? I'm sorry, Your Honor.
No, what were you saying, sir? Go ahead.
I was gonna say, what do you mean vacate? I'm getting evicted if I can't pay it. I already talked to the one attorney.
Sir, what I was starting to say is that it sounds as if you already have some arrangement or some conversation with Belleville Manor. I would encourage you to continue to be in contact and communication with them about paying this amount. The court does not typically get involved in payment plans regarding past due rent. I'm not saying you're being evicted. I'm saying be in communication and contact with your landlord and continue to make the payments that you've been making.
I apologize for cutting you off, Your Honor.
No, sir. Listen, Mr. Hulslander, I understand that this is your where you live. And the words are shocking to hear that you need to pay or vacate.
Yeah, I'm only 24. This is the first time I've ever been late in 3 years here, with the rent being over $1,300 every time. So I mean, I'm not trying to get over none. I'm trying my hardest. I had a rough little patch. I'm trying.
Sir, I understand completely. I heard you say rough patch. I hear that you're working and you're trying to make it work, considering what your girlfriend is going through. But I'm saying to you, pay or vacate does not mean you're being evicted, doesn't mean you have to move out. It means that you
I
need to
understand
keep
that.
the lines of communication open with Belleville Manor, okay?
Okay, thank you.
Was there anything else, Mr. Horn?
Just for record keeping, Ms. Jones is not present, so I'll just mark them as a default of no different terms, Your Honor.
Correct, sir. Thank you.
Thank you.
Mr. Hofflander, you're free to go. You have a good day, sir.
Thank you.
Thank you. And Mr. Horn, Miss Askew is here physically in the courthouse. I'm gonna have staff bring her in right now. I have a 10:30 and 11 o'clock, but I will take up the Askew matter in just one moment.
Thank you.
Hey, would you have the Askew come in, please? Thanks. Bye.
Left side?
Yeah, because you're getting, you can sit on that side if you want. Or this side, wherever you want to sit.
Testing 1, 2.
This is 2401210 West Village Estates versus Askew and Askew. Would you please state your names for the record?
Danny Horn, PA 1774 for plaintiff.
Sir, your name?
Lowell Askew.
And ma'am, your name?
Dion Askew.
Thank you. Today is the day and time scheduled for the second hearing in this matter. Mr. Horn, what is the rent to retain possession?
Rent is $1,515.46. Court cost $231.71 for a total of $1,747.17. We're asking for a possession judgment today for those amounts.
Thank you. Now, Mr. Askew, this case was originally scheduled back on March the 7th, and you did not appear. Did you?
I have no idea.
You didn't receive a notice to appear previously?
Did I? No. No, ma'am.
Okay. Sir, you were able to hear the attorney indicate that there's past due rent of $1,515.46. Is that amount correct?
I believe so, but I'm not sure. Be better to ask her.
Miss Askew,
Yes, ma'am. Yes, Your Honor.
is the amount of rent claim due and owing accurate?
No.
What is the amount of rent due?
I have 2 money orders for $700 each.
700 each and?
I am also claiming a breach of the lease, breach of the contract of the lease.
And what is that breach, ma'am?
Before, with January, my signing of the lease for the new year was December 23rd. And my price should have been locked in, and the system put me on a month in January and February. And I also received a letter from West Village Estates saying that I should check at the office with them because I failed to, I think I got it right here in front of me. Our records reflect you have not elected to sign the new lease. This was sent to me USPS mail, and this is dated January 1st, 24. I had signed the lease December 23rd. But this letter indicates our records reflect you have not elected to sign a new lease. Please be advised, effective this month, you are being charged $37 monthly premium for month-to-month tenancy. That's a breach.
Ms. Askew, when we were here on the 7th, I believe, you had a chance to speak to the attorney for West Village Estate?
Yeah, through video.
Okay. And did you discuss this with him?
No, I did not.
Mr. Horn, do you have any information regarding?
I'm looking here at the site lease agreement that they're talking about. I don't know what the dispute would be regarding. The amount of rent is what's in question. I'm looking here at a lease that was signed on 12/26. It looks like got both, or at least Dion Askew's name. So I'm not really sure what they're disputing, other than the fact that when we spoke the first time, it was over whether or not the system was accepting payment, and there was a problem with the online system. They were notified of that on February 5th. They were told if you make your payments through, as you can hear, the money order, that they would waive any fees applicable to that. Normally, if there's a money order payment, there's an additional fee. They were told, since obviously the system's down, we wouldn't be charging, my client wouldn't charge them a fee to make a payment through a money order. Those didn't come. And at this point, there remains more than what they state is in their money orders. And so payment in full has to be made.
Here's my problem I have. She hung this on the door of the 5th, and it was a Monday after the weekend. And she hung it on the door or talked to Mr. Askew at 2 or 2:30 in the afternoon on 12/5/24. I made a note of it. And not all residents got this because they have automatic payment through.
Ms. Askew, I'm going to interrupt you because this is the problem. When you were here before, you indicated to me that you wanted to be here in person. And I advise you that you have an absolute right to appear in person, but you're referring to documents and you're showing me things that Mr. Horn cannot see. So, and I don't know who she is. So my question originally to you was the amount of rent he indicated doing accurate? And first thing you said to me is that you have these money orders for two money orders for $700. And I don't know if those are money orders you've actually tendered to him or tried to tender to West Village Estates.
They're in my car.
I don't know what this pink thing is that you're waving.
Yes, ma'am.
Okay.
So what am I supposed to answer your question? What is your question that I didn't answer?
If the indication from West Village Estates is that you owe $15,1546 and then court costs of $231.11 for a total of $1,747.17, then your indication to me is that you have two money orders totaling $1,400. Are you disputing the other $347.17 or?
Yes, I am.
Okay.
I refuse. I read up on, there's not a lot of attorneys that will help with tenants' legal matters. And because there's no money for the attorneys to be made. So therefore, I did some investigating at the Romulus Public Library, and I believe I have the right to, number one, I couldn't pay my rent on the 5th because I went to the bank that I have a debit card with a Social Security disability. And because my license was expired, but I had the temporary, they refused at the bank level they said I could go to the ATM. I couldn't do it in person at the teller window due to the fact that they have to scan my ID, and my ID came up in their system as expired. This is the ID. I had got it renewed several days before my birthday. And so the bank turned me away for face-to-face. She informed me that I could use the ATM, and I said that would be 2 transactions. And that was just a hassle because I know I can go straight to Kroger's and get a money order and not have to show this ID. And I had my, the other one came in the mail in the meantime, but this is what I had on the 5th when I went to draw my money orders from the bank, from my debit card, to get a money order for her. By the time I was done at Kroger's, after they refused me at the bank, Comerica Bank, which the debit card is from, and it's also Social Security disability I receive once a month.
Okay, so Ms. Askew, the response is, yes, you owe money, but you dispute the amount that Mr. Horn is indicating.
That is correct.
Okay, then Mr. Horn, my question will be to you. Are you ready to proceed with a full hearing in this matter with documents and witnesses?
Yes, Your Honor. I would like to know what she thinks the amount is, if there's something that we can discuss, because I'm not understanding. I'm staring at a lease that they signed and was renewed. Simply saying I dispute it. What is the dispute?
Danny, please read the emails I have sent you, messages, please. I think it explains everything.
Ms. Horn, I'm sorry, Ms. Askew, what amount are you claiming as due?
Just straight rent plus my water.
A dollar
And
amount.
I called for the office, which is our landlord. I asked Renee to please zip off. They just had another system change.
Ms. Askew, stop. Dollar amount
That
you think you owe.
I think the 1,400 would cover more than the amount, because I do not know, I should not owe the late fees for 2 months.
Mr. Horn?
And the court costs.
So
I'm disputing that.
You're disputing the court costs.
I'm disputing the court costs, and I'm disputing the amount, there's the late fees because of I'm disputing the breach because of this glitch in their system. And I was unable, I'm not just gonna drop off $700 money order in Renee's Dropbox, which is our landlord, Renee Sample. I am not gonna, I have looked at her ledgers for 10 years, and I'm calling disputes in her bookkeeping and her ledgers. On my property that I own the home.
Stop, please, for 1 second.
Yes, Your Honor.
Your Honor, there was the month-to-month issue that she mentioned before. She's received the credit.
I'm sorry,
that-
Mr. Horn, stop for 1 second, please.
Sure.
2401587 Holiday Woods versus Brandy Williams.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Holiday Woods.
Thank you. Today is the day and time scheduled for hearing in this matter. The court has checked the file. There's been court mail mailed by plaintiff and posting by plaintiff. Case was scheduled at 10:30. It's now 10:50 by the court's clock. Defendant failing to appear. Sir, how would you like to proceed?
Your Honor, at this time, we'd ask a default judgment for possession to be entered. Rents retained are $2,533.71. Court costs of $190.24 for a total of $2,723.95. And we will submit that proposed default judgment for possession only to the court.
Thank you, Mr. Morton. Have a good day.
Thank you.
Back on the record in 2401210 LT, Mr. Horn, you were starting to say the month-to-month fees.
Yes, it was a point that Mrs. Skew addressed, and there was a $74 month-to-month fee. She got a credit for that in January of 2024. She signed a lease that started in January of 2024, goes through December 31st. The base rent for that is $669 plus the $3 site tax fee that's applicable. So there's a Dropbox that's available. Her refusal, I'm not sure how refusing to pay when told would somehow entitle her to a waiver of a late fee when she's got an opportunity to put it in the Dropbox.
I answered your question. Danny.
Yep.
Mr. Horn, Miss Askew has made a demand for a jury. She has paid the jury fee. She is entitled to a jury trial in this matter, inasmuch as she disputes the amount of rent claim due and owing. That being the case, how would you like to proceed, sir?
If there's a necessity for a jury trial, then we can do that.
Would it be advantageous to the parties at all to discuss this matter?
I'm happy to discuss the matter. If we want to do a breakout room, if they, I don't know how they would want to do that since they're in person.
I don't know if there's somebody downstairs in the Zoom room. If that room's available, Ms. Askew, Mr. Askew, I'll have you go downstairs so that you can have a breakout room. There's no way for me to give you
Face to face.
it's available. Sandy just responded, it's available. So Mr. Horn, I'm sending Miss Askew, Mr. Askew downstairs into the Zoom room.
Okay.
If you reach an agreement, you'll come back and place it on the record. Otherwise, we'll have to schedule this matter. Ms. Askew, if there are specific issues you have, that will be the time to raise them. We need to dispose of any pretrial matters, issues that you have with West Village, okay?
Okay, one question, Your Honor. I have my original copy of all my ledgers from Sun Communities. I called their office. I also received partial ledgers from Renee Sample, the landlord, after this big glitch in the system on the weekend.
Ms. Askew, no. He's indicated a willingness or a desire and interest in speaking to you about this matter, so go downstairs and talk about that. Mr. Horn's indication on the record was that the glitch or the month-to-month fees that should not have been charged have been credited. You all should be able to have a conversation about confirming that those credits have been made and confirming what the balance is. If you go downstairs, Officer Brooks will help you get logged on, or someone will help you get logged on. You can rejoin this court session from that area downstairs, and it looks like someone's already logged on in the room for you. They're just waiting for you and Mr. Askew to get downstairs.
I agree, Your Honor.
I'll be here though, if you need something else from me. Thank you. Mr. Horn, it'll take them just a few moments to get downstairs.
So if I disagree with this, they will go to jury trial?
We need to come back up here because before I summon 30 people from work and their other obligations, I want to find out what the issues are.
Right.
This hearing is an opportunity to dispose of any pretrial issues and narrow the issue down. If we're talking about a dispute over $100 or $150, we'll have a different conversation collectively. Thank you. I'm sorry, Mr. Askew?
Can I be dismissed? I'm really sick. I've been sick for like 3 days. Been here since 9:30 and I really don't see much going on that involves.
Do you live at the property?
Yes.
Then you're responsible. I mean, if you wish to leave, you may leave. I can't make you stay in court if this is not where you want to be, but you're a named party. You're a named party to a landlord-tenant non-payment of rent case.
She has all the information. I don't know it.
You don't know, okay. Again, Mr. Askew, I can't force you to stay, but you're a named party and you're responsible for any agreement, well, not any agreement, you're responsible for any rent that remains due. If that makes sense to you. Okay? So please go downstairs. You'll be able to go into a breakout room with Mr. Horan.
Thank you. Is he escorting us?
He is.
That would be nice. Thank you.
Thank you. And Mr. George, we'll resume. I am sitting in for Judge Oakley on this afternoon's docket. So if your office is logging back on for that, I will see you at noon.
All right, very good, Your Honor. Thank you.
Thank you. Mr. McCausland, my policy is 15 minutes after the scheduled start time unless you've received some communication from Mr. Smith or you've resolved this matter with Mr. Smith.
I've received nothing from Mr. Smith.
Okay. Let's give him a few moments to log on.
It was scheduled for 11 o'clock.
Yes, sir.
So he has until 11:15.
Yes, sir.
Thank you.
Thank you.
Your Honor,
Mr. George?
I was just wondering, is the afternoon docket going to be here on this Zoom, or are we going to be switching over to Judge Oakley's Zoom?
Judge Oakley's, because I believe that's what was on the notices that went out to the tenants.
Okay, thank you very much.
You're welcome.